Welcome to everyone who has joined us already for this event. Thank you for being here. We are going to wait a couple of minutes more to allow people to arrive, and we will start. Thank you. So good morning or good afternoon to everyone who has joined us for this event. This event is co-hosted by the Forum on Arms Trade, Control Arms and PACS. And my name is Canel Lavitte. I am the co-director of the European Center for Constitutional and Human Rights, ECCHR, Berlin-based human rights organization. I co-direct the Department on Business and Human Rights, which focuses, amongst others, on the responsibility of corporate actors involved in arms exports in relation, in particular, to the conflict in Yemen. Before I introduce you to the speakers who have kindly accepted to share their inputs for this very interesting discussion today, I would like to share a few information on how the event is going to take place and a few technical information as well. So we're going to start with half an hour of inputs from our three panelists. And after that, there will be a Q&A session. You can already put your questions. You can put the questions in the Q&A box that you should see available on Zoom. Questions will be selected on the basis of upvoting. And you can also interact through the chat box, share resources or share comments that you find relevant for the discussion of today. This event will be shared also and live streamed on YouTube. Which will also be embedded on the event page. With regards to the end of the event, you will normally see popping up when you exit the event a link to a survey that is being brought to you by the organizers of this event, and it will be very useful for them if you share your input on how it went and what could be improved or not, so that the next event can be even more interesting. And the organizers have also planned to share resources and recommendations as follow-up to this event in a few days. So stay tuned. The discussion doesn't end today. So today's discussion is about the Arms Trade Treaty and arms trade, trends in financial and corporate responsibility. This is an extremely relevant and timely topic because the responsibilities of corporate and financial actors in the arms sectors, contrary to the responsibilities of states, are still in the making. While the Arms Trade Treaty and other regional and international regulations address the role of states in their issuing of licenses for arms exports, the obligations of business actors, and in particular, investors or shareholders who produce, who export, who invest, and profit from those arms exports needs to be further developed. At the same time, I think it's becoming increasingly clear today that when defense companies continue to supply weapons to countries that are involved in armed conflict or in severe human rights violations, despite publicly available information on these violations, they bear major financial, legal, and reputational risks. Investors and shareholders have started to care and should care about these risks because they may ultimately fall on them as well. Moreover, the development of human rights due diligence indicates that financial actors and shareholders bear an actual obligation, bear certain responsibilities independent from states' obligation to respect human rights and to mitigate those risks. Today, I think, is a very timely event because, as some of you may know, last week, the United Nations Working Group on Business and Human Rights issued a long-awaited information note on the responsibilities of business actors in line with the United Nations Guiding Principles on Business and Human Rights, which remains to this day an essential instrument for defining their obligations of those actors, financial actors who engage, financial and corporate actors who engage in arms trade. So in order to discuss today what those human rights due diligence obligations are for investors, shareholders, we have three distinguished panelists who all have extensive expertise on interrelated topics that are relevant for the discussion. So we will start with Cor Udes. Cor is a program leader in humanitarian disarmament, business conflict, and human rights at PAX, a Dutch organization. Cor works for stronger international standards for disarmament and responsible company behavior in conflict zones. And today, to steer the discussion, he will discuss the recent PAX reports showing that despite investment policies acknowledging the risks involved, largest 15 banks in Europe have invested up to 87.7 billion euros in arms companies that sell weapons to states involved in human rights violations or armed conflict. We will then continue the discussions with Dr. Lana Baydas, who is a senior program manager at the American Bar Association Center for Human Rights. Dr. Lana Baydas has extensive experience working on the protection of human rights with a focus of the Middle East and the North Africa region. She previously held posts at headquarters and in field operations with the United Nations, with Crisis Action, as well as the International Committee of the Red Cross. She will be bringing in the discussion newly published American Bar Association's findings, as well as recommendations on the responsibility of arms manufacturers to respect human rights due diligence and implement human rights due diligence programs. We will then continue the discussion with Gillian Lyon, who is Program Director at Investors Advocates for Social Justice, where she leads shareholder advocacy campaigns amongst a range of work. She will talk about recent shareholders resolutions at defense companies, such as General Dynamics or Lockheed Martin, that focused on human rights due diligence, but also making broader observations from her research based on efforts related to climate and environmental justice that together may change the landscape also for arms producers. So I would like to start with Cor, asking you, Cor, if you could share what your research and this report have found in terms of the risk for arms companies in several contexts that you have identified, and the policies that you were able to analyze for the banks that you've been researching. Please, Cor, the floor is yours.
Yes, Thank you very much, Kanel, for that kind introduction. And I'd also like to thank the Forum on the Arms Trade and Control Arms for co-hosting this webinar. In my introduction today, I'd like to focus on three things. First, the issue of high-risk arms trade. And second, the importance of human rights due diligence by arms producers. And third, the role of the financial backers of these arms-producing companies. PAX is a Dutch peace organization, and we work in 15 conflict and post-conflict countries. And these include active conflicts like Yemen and Iraq. And what we see in many of these conflicts is that the influx of new weaponry often helps to escalate the conflict, and it leads to human rights violations in some cases. In Yemen, we work, for instance, with our partner Moatana for human rights, and a 2019 study by Moatana and PAX examined bomb fragments found at bomb sites in Yemen where significant civilian casualties had fallen. Just the slide needs to click. Yeah, there it is. The analysis in this report showed that many of these bombs were produced by companies in the United States or in Europe, and then supplied to the warring parties in Yemen. And this is one of many signals that arms producers face extensive risks of being linked to violations of international humanitarian law and of human rights. And past July, PAX published a study that examines this risk further and also looks at the exposure of the financial backers of these arms companies to said violations. In our study, we operationalized the risk which arms dealers face by looking at 6 indicators to identify high-risk countries. And we then identify which arms producers have exported weapons to these countries. And our study found that at least 15 of the 25 largest arms producers in the world supplied military goods to these countries, despite the risks. And this includes fighter jets, bombs, missiles, helicopters, engine maintenance services, as well as other military goods. And this all went to countries like Saudi Arabia, the United Arab Emirates, Iraq, India, and other countries that are at high risk. My second point for today is a point that other speakers in this panel will examine in much more detail. It's the responsibility of arms producers that they have to respect human rights. And this responsibility is based on common sense, but it's also formalized in international standards, such as the UN Guiding Principles on Business and Human Rights, the OECD Guidelines for Multinational Corporations. When arms companies translate this responsibility to their own sector and to its own risks, the Arms Trade Treaty must be front and center. This treaty makes it very clear that weapons should not be transferred if there is an overriding risk that the weapons would undermine peace and security or risk violating international humanitarian law, amongst other criteria. And the EU Common Position on Arms Exports makes in the basis a very similar point. The responsibility to mitigate the risk that the ATT points to lies with the arms producers, as, like Kanel already mentioned, the UN Working Group on Business and Human Rights affirmed in a note published last week. This responsibility also extends to their value chain, and that's my third point for today. Their value chain includes their financial backers, and in our study of July this year, we examined how the largest European banks deal with the risk of financing a company involved in high-risk arms sales. And the study included banks like the Dutch ING, German Deutsche Bank, French BNP Paribas, and also NatWest, which is based in the UK. In total, 15 banks. And we found that, actually a bit to our surprise, quite a few banks, 8 out of the 15 banks that we studied, had decent to good policies that exclude certain types of financing based on how the company, the arms company, acts and how it behaves when it comes to arms sales. The policies of these banks try to mitigate the risk that the bank invests or finances an arms company that sells weapons to a conflict zone or to a known violator of human rights. However, we also identified significant gaps in the policies. Our study examined 2 banking activities, lending and underwriting. Those are in the underwriting is in the third box, lending is in the first 2 boxes. Lending can take different forms, hence there are 2 boxes. And one of them is trade finance. Trade finance is an activity of a bank to help finance a very specific arms deal. And we found that of the 8 banks that had good to decent policies, 5 would exclude trade finance if the deal they were to finance had a high risk of leading to human rights violations or violations of international humanitarian law. That's in the first box. However, these same banks would provide other types of financing, such as general loans or underwriting in the second and the third box, to the same arms producer, despite the high-risk arms sales by this company. And thus, we found close to 90 billion, 87.7 billion euros in financing by all 15 European banks combined in the arms producers in the study, 15 in total. So 15 banks and 15 arms companies, and a financial link between the two that amounted to 87.7 billion euros in financing. In our view, these banks are effectively, through their financing, still linked to violations of human rights and international humanitarian law. And this means that the banks have to act. And with that, I'd like to close for now.
Thank you very much, Cor, for this synthetic but yet very clear overview. I would like to turn to Lana, because I mean, what your report shows, Cor, is that the human rights due diligence of financial actors is very closely linked to the main concept of human rights due diligence that applies to arms manufacturers. So, and reading the UN report from the UN Working Group on Business and Human Rights, there are many challenges to implementing, but also framing that obligation of human rights due diligence. So Lana, could you please walk us through the findings of the American Bar Associations on that?
Great. Good morning and good afternoon, wherever you are. Thank you, Kanel, for your kind introduction, and thanks to colleagues at the Forum on the Arms Trade, Tax, and Control Arms for organizing this timely event. I will focus in the next few minutes on the responsibility of armed companies to respect human rights, which entails setting up a human rights due diligence program. As you can, excuse me, and Cor just noted, the international and regional legal and regulatory frameworks place on state the responsibility to prohibit weapons exports where there is a clear risk of being used in violation of international human rights and the humanitarian law. The Arms Trade Treaty, as Cor mentioned, expressly incorporates respect for human rights and international humanitarian law as a precondition for the international arms trade. The domestic legal framework, to a certain extent, and despite the existence of numerous gaps, place similar requirements around human rights and humanitarian law violation in undertaking arms sale and transfer. However, the fulfillment of these obligations has been mixed at best. According to a recent report of the US Government Accountability Office, from fiscal years 2015 through 2021, the US Department of Defense administered military support worth of at least $54.6 billion to Saudi Arabia and UAE, primarily for defense articles and defense services. The arms sale to these two countries continue despite the findings of the UN civil society organization that the coalition strikes on Yemen have been indiscriminate and may amount to war crimes. So one of the challenges for continuing sale to countries with poor human rights records and commission of violation of international humanitarian law, as identified by what Kanel mentioned about the newly longly awaited information note of the UN Working Group on Business and Human Rights, is a lack of the human rights due diligence conducted by armed company. While, as we just discussed, while the primary responsibility to protect the human rights lies in states, companies still have the responsibility to respect human rights, as affirmed by the UN Guiding Principles on Business and Human Rights and OECD guidelines. The responsibility to respect human rights requires companies have policy and processes in place to prevent, mitigate any risk of causing or contributing to adverse human rights impacts. So the defense, what we found that the defense industry often pushes back against fulfilling its responsibility to respect by invoking the argument that they follow domestic regulatory frameworks and that the diligence is performed by regulators in approving sales or in granting export licenses. However, as explained in the UN guiding principle, the responsibility to respect exists independently of states' ability and or willingness to fulfill their own human rights. The ABA Center for Human Rights Guidance further demonstrated that advancing these arguments would not shield the arms company from reputational, financial, regulatory, and legal risk, as you just mentioned, Kanal. We have seen litigants succeeded in pursuing path to civil liability against US weapons manufacturers. In Europe, the report looked at the prosecutor have brought criminal charges, excuse me, against defense company who violated the terms of their export licenses or are alleged to be complicit in war crimes and crimes against humanity abroad. With that in mind, as part of fulfilling their responsibility to respect, as proposed by the center guidance, companies should engage in setting up a human rights due diligence program of 4 practical steps: risk assessment, prevention and mitigation, end-use monitoring, and investigation and remediation. This means defense company must assess and address the human rights risk and abuses arising on all aspects of their businesses, including, and in my opinion, perhaps it's the most safeguard, is to monitor the client use or misuse of the weaponry and related services. Let me stop here, and I look forward to discussing the recommendation and answering the audience question and my co-panelist question. Thank you very much.
Thank you very much, Lana. Gillian, I mean, in this multitude of actors that are part of the arms industry, we've talked about state actors, arms companies, but also banks. Shareholders, I think, hold a very specific position. They have means and they have power to try and mitigate all those risks that we've just mentioned, but also to change practices from a more structural point of view. So can you tell us what are those resolutions that you've documented, and how do you see shareholder activism in the field of arms trade?
Thanks so much. Yeah, I'd love to give a bit of background about our work and how the shareholder responsibility and lens kind of fits into here. So a bit of background on Investor Advocates for Social Justice. IASJ is a nonprofit that represents institutional faith-based investors to promote human rights. We build on a really long history of faith-based women and BIPOC-led institutions that have championed movements for peace and demilitarization. So as investors, IASJ uses our financial leverage to engage companies in the defense and finance sectors, to publicly acknowledge how these companies perpetuate human rights harms, and then to push them to address immoral operations that endanger global peace. Cor and Lana gave a really good overview of the UNGPs and what, the corporate responsibility is to respect human rights, and also how many of these companies are failing to meet their responsibilities. And there's a clear moral imperative for investors to acknowledge the direct role that this industry and its financiers are playing in perpetuating harms in war and conflict. So in our advocacy, IASJ emphasizes the systemic risk across portfolios in the world economy created by the lack of due diligence. And these kinds of military sales and operations that Cor and Lana have outlined do not promote global security. We also know that the defense industry is draining the US federal budget at a time of the pandemic, climate crisis, racial inequities. Not only is the US Department of Defense the world's single largest institutional consumer of petroleum, but border militarization and oil-fueled conflict exacerbate humanitarian crises. And as we all know, these outcomes disparately affect women, children, people of color, people living in poverty, and other marginalized groups. So speaking just about the US, we still have generations of families affected by nuclear testing and other environmental pollution related to weapons production. But this is an issue that is felt globally. UN experts warn that this is among the cruelest forms of environmental injustice. So it's not just isolated to the defense sector and international conflict. IESJ engages 4 of the major US defense contractors on human rights issues related to their operations and products. So that's General Dynamics, Lockheed Martin, Northrop Grumman, and Raytheon. Independent reporting has consistently shown that these companies and their peers are failing to address human rights risks. So on this slide, I've pulled up just a few examples of how this is manifested. The first picture here is an F-16 fighter jet equipped with General Dynamics gun systems that have been connected to repeated attacks on civilian and refugee areas in Palestine. The second is fragments of a school bus bombing in Yemen that killed dozens of children that have been allegedly linked to Lockheed Martin and General Dynamics products. The third is the Apache helicopter equipped with Northrop Grumman's Longbow system that was used by the Israeli military during the May 2021 attacks on Gaza, where apparent war crimes were committed. And the last is shrapnel of an Mk-83 bomb linked to 2015 airstrikes on a school in Yemen, which has been sourced back to Raytheon. So these are just a few examples, but all of these companies engage in business or weapons sales to conflict-affected states involved in human rights violations. I will go into more detail about each of these companies and how we're pushing them to improve practices later on. And also in sharing the slides, we'll link to all of these allegations that I've shared. But for now, I will turn it back to Kanal.
Thank you very much, Gillian, and a very warm thank you for the 3 panelists who so far have been extremely diligent on keeping the time and therefore keeping more time for questions. Thank you for this. So now that we've got sort of a theoretical or rather landscape background from our 3 panelists, I would like to turn back to you, Cor, so that you give us a bit more information on the recommendations that you're making in your report. I found the part of your report that goes through the policies of some of the banks that you've investigated and explains how those policies are sufficient or not. Very interesting. And it seems to me that the devil hides themselves in the details from at times, because some of those policies on the paper looked actually quite advanced. So what are your recommendations to those banks?
Yes, thank you, Kanal. I'll focus my recommendations on the financiers then, on the banks. As you pointed out, some of the policies that we examined in the report are quite detailed and look impressive, as I also indicated in the presentation. That's the case for 8 out of the 15 policies that we examined. So my recommendation for the other 7 banks is quite straightforward. Basically, is to take a look at the other policies and copy the value part of it and start applying them as soon as possible, because their policies, so of the 7 banks that we consider to have no or very poor policy, the recommendation is quite clear. They need to improve their policy and then implement it as soon as possible. 8 of the 15 banks have policies that we would qualify as quite decent or even good. And that means that their policies include or pay attention to the risks that we also list in the report should be used as screening criteria for arms companies in the first place before they sell weapons or before they sell weapons to another country. Second, by banks investing in arms companies before they invest in an arms company that is exporting weapons, perhaps to a country that would be on the warning list if you look at these criteria. So for the 8 banks that have decent policies, the recommendation would be to fix the gap, because there's a significant gap in their policy, which limits the application of their policy to basically only one financing activity, and allowing for other financing activities to continue to go on. That's the case then, for instance, for revolving credits, for underwriting. Apparently, this still gives quite a lot of leeway given the total amount of investments that we identified. close to 90 billion euros in these arms companies. So these banks are aware of the risks. They're writing them out. They're listing them. They need to make sure that they're filling the gaps and applying their screening on these risks to all their financing. Just one.
Thank you very much, Cor. Turning back to Lana, I found very interesting that your very last point when you said, well, that in your view, the monitoring of the use by the client is really what is at the core of human rights due diligence. And at the same time, what we hear from companies when we engage in litigation against them in the context of Yemen is that they just don't have the means to monitor what the client is doing. But we also see the increasing use of end-user certificates given by the client as to how they will not use an arm for the commission of human rights violations. And those certificates are increasingly being relied upon by those companies to sort of exonerate themselves from liability. So how do you think this should be navigated? And what is your analysis on this?
Thank you, Kanel. So I would say I will start with for any effective human rights due diligence, we need to put the house in order. And to start with, and as noted in the responsible business conduct in the arms sector information notes by the UN Working Group on Business and Human Rights, the international community should define what clear risk for the prohibition of arms transfer constitutes. So it's not left to the subjective interpretation of member states and tailored to political interest and will. And also we need for states to include a mandatory human rights due diligence for arms company in national legislation. Without a strong and meaningful commitment, any due diligence processes would be merely checking the box. And also, again, putting the house in order, states should harmonize their terms with regard to the prohibition of arms transfer. There are different stands to what point the arms transfer prohibition applies, some at the actual knowledge, the knows, and back to your point, Kanel, while others at the constructive knowledge should know of a likelihood of misuse. This variation could result in exploitation by exporters to find lenient jurisdiction. And that's leading to what's the human rights due diligence should be. And again, back to the point about the arms company have the capacity to know because they have a life through a relationship with the client in terms of support, in terms of being engaged, in terms of what kind of continuous transactional relationship. So armed companies should integrate in their human rights due diligence program a component of end-use monitoring. And this is to ensure that the defense articles and services are not involved in the commission of serious violation of international human rights and humanitarian law. And this could be done by arms exporters requiring that their clients submit periodic and incident reports and put it as part of their contractual agreement concerning the usage of the defense articles and services, complementing the efforts of the regulatory authorities to monitor the diversion of weapons. And exporters should engage as well in a periodic audits and site inspections and track development by collecting open source information and consistently engaging with the client and other stakeholders, particularly civil society organizations who have the capacity to provide collaborated information on the use of these weaponry.
Thank you, Lana. That answers the question and even more. Thank you for your clarity. So to finish this round of inputs, I think we really need to hear also from you, Gillian, on those concrete examples that you've documented of shareholders exercising those responsibilities and powers that they have in relation to the arms sector. Please go ahead.
Absolutely. I wanted to focus in on specific examples, what we see as barriers to change and how we're working to address human rights harms that we've all been talking about. I think similar to what Lana and Cor have said, we hear very consistent messaging from these companies. Really two things. The first is that human rights due diligence functions are carried out on their behalf by governments who are licensing arms transfers. And the second is that they don't explicitly identify the misuse of products and services by third parties as requiring any additional due diligence procedures and policies. However, investor expectations on human rights due diligence are increasing, and failure to meaningfully assess these impacts exposes companies and investors to material risk, including legal, financial, and reputational impacts. I'm going to walk through examples at General Dynamics and Lockheed Martin to show how these kind of impacts and risks are manifesting, how we're identifying them, and how investors are pushing to address adverse outcomes. So the first company here is General Dynamics, which is the 5th largest defense company in the world. General Dynamics weaponry and technology has been repeatedly linked to alleged war crimes related to civilian deaths in Yemen, Palestine, and other areas. The company denies any linkage or responsibility, despite the end use of its weapons directly contributing to impacts. And importantly, the company's existing policies and practices fail to demonstrate robust due diligence related to high-risk products and services, and it doesn't have a commitment to address irremediable human rights impacts. IASJ filed a shareholder proposal with the company, which is essentially a request presented to the company, which is voted upon by all shareholders at the annual meeting. The Franciscan Sisters of Allegheny, who we represent, are investors in General Dynamics and filed this proposal requesting reporting on human rights due diligence. It received 25% support from investors in 2022, which is fairly high for a shareholder proposal, particularly in an industry where the core business model is just so inherently at odds with respect for human rights. So this is showing that even investors of the defense industry have growing expectations for human rights due diligence that goes beyond legal compliance and the other arguments that we're hearing. And then the second example here is Lockheed Martin, which is the world's largest defense contractor, doing business with over 50 countries and connected to a wide array of weapons and defense technologies. Prominent human rights organizations have recorded indiscriminatory use of Lockheed Martin weaponry against civilians and specifically children consistently over time. And in the past few years, Lockheed Martin has exported military goods to at least 12 states, which are engaged in armed conflict, have a record of human rights violations, or are at risk of corruption or fragility. The company is also connected to $40 billion in contracts related to nuclear weapons. Just to note, we are at a time where we are at higher global risk of nuclear detonation than during the Cold War. So like General Dynamics, they also lack sufficient policies and procedures to address these human rights risks. And on behalf of the School Sisters of Notre Dame, we filed a shareholder proposal requesting a human rights impact assessment, which received 20% support from investors in 2022. Again, a fairly high vote for a human rights ask, especially in this sector. We also filed similar proposals with other defense contractors, as well as banks that finance nuclear weapons and other activities. And overall, we are seeing momentum for mandatory due diligence. As I mentioned earlier, this is not an issue of just the arms trade. These weapons, from the funding to production and end use, are interconnected with our climate, global health, migration, and a broader vision for peace. So as a recommendation, we really need an interconnected vision for mandatory human rights due diligence that prioritizes these high-risk products and services, especially in conflict-affected areas. And the financial sector must be part of the solution. Investors do have an obligation to ensure that they're not contributing to harm. So we hope to see these recommendations, at the company level that we're making with these shareholder proposals, and also more broadly, as Lana and Cora have outlined as well, integrated into our economic systems to encourage a more positive vision of society. And with that, I'll turn it back to you, Canal, for maybe the Q&A section.
Thank you very much, Gillian, and all panelists. I invite you all to turn on your camera so we can get into the second part of this event for more interactive discussion. And I see that there are quite some questions already in the chat. So I'm going to start by selecting one or two on the basis of the upvotes. One, I think, relates a bit to the methodology of the research from Enrique Garbino. I imagine the question is that several banks and companies might be reluctant to share information openly and talk about their policies. So how, I would imagine this is maybe for Core, but actually for the three of you. So I leave to you to decide who wants to answer. But how have you circumvented the potential withdrawing of information from the banks and companies that you've investigated?
Yes, I can start answering that question, and then Gillian and Lana can add on if they want to. So there's a limit to what we can get in terms of information from both the banks and the companies, but actually quite a lot of information is publicly available. So we make it a point of principle to take into our investigation policies that are published. We believe that banks, as well as companies, should be open about their principles when they're investing and when they're doing business, that they should also be accountable, which is only possible if you've stated publicly what your beliefs, what your purpose in business jargon is. And that's for banks and for companies. So many banks publish a defense policy. Top of my head, I think only 2 banks didn't have a dedicated defense policy published. And 13 of the 15 banks did. So they're quite open, and I found that quite a few banks were also quite open to engage with us and to discuss how to interpret various aspects of their policy. When it comes to the companies, the arms companies in question, some of them, we've also asked them questions, and we've asked them basically as a first question to verify the arms exports that we had identified. And we identified those mainly through the work that's already done by SIPRI, the Swedish Institute for Peace Research, Stockholm Institute for Peace Research, my apologies. So they publish a database that contains arms exports country by country, which we then link to companies. We do that at PAX, a valuable colleague of mine does that. And then we check with the companies if that's correct. And none of the arms companies has actually entered, has said anything about that, claiming what the asker of this question is also already alluding to, that they are not open about any transactions. At the same time, of course, quite a few of these transactions make the press or are published on their own website. So quite a lot of information is open. We check what we publish in the report before we publish it. And we rely on databases that are generally seen as quite credible when it comes to this type of information.
I'd also like to kind of add to what Cora was saying, more around the investor side. Human rights due diligence is financially material information, especially when a company is producing and selling products that are intended to result in some of the most irremediable human rights impacts. Investors need to know how the company is assessing and managing these risks. These arguments of deferring to government licensing or kind of very general policies is not sufficient to demonstrate that a company is meeting its human rights responsibilities. And we see increasing investor support for this notion. So just kind of adding on the risk management side, even this information, it doesn't need to be proprietary information to understand how a company is looking at these risks, actively working to mitigate and change its products, services, and policies around human rights due diligence.
Thank you both. Do you want to add something, Lana, maybe, on this question?
Just quickly, similar to what Cor and Gillian noted, our approach was similar, relying on open available information. Throughout the process, we engage with a number of stakeholders, including armed companies, and laying out all the information regarding the risk and the risk that companies may face, and we rely into and anchor it on our due diligence and suggested due diligence program based on legal and regulatory available frameworks.
Thank you very much for your answers. I see another question that seems of interest from Roy Easter. Sorry, Roy, for mispronouncing your name, from the Forum on Arms Trade. That's a question on a very important point, right? Like supply chain. Would you make a distinction in the extent of due diligence that is required between prime contractors as opposed to the suppliers of sub-assemblies and components, etc.? Again, Lana, Cor, Gillian, I think I leave you to the three of you to decide who wants to speak first. Okay, I can decide as a moderator. Lana, please go ahead.
Okay, thank you very much. I think I would, in terms of the supply chain, I think in the human rights due diligence needs to be taken into throughout the value chain, and it's not a differentiation. Each one has the responsibility to respect, and this is where I see it needs to go also beyond the value chain and to go into the end use monitoring. And this is where I think in this responsibility, it should be clearly indicated in terms of what and how and when and to assess and address these risks. So I would take no differentiation, but rather a concrete assessment throughout the value chain. As Cor mentioned, the banks have the responsibility to respect the human rights, and similarly throughout the value chain and with the end use monitoring.
Gillian or Cor, do you want to add something? Gillian, yes.
Yeah, sure. I can add. I definitely agree with Lana. The relationship and leverage that manufacturers and other producers might have throughout the supply chain could look different when you're looking at the specific mechanisms of how to fulfill those responsibilities. But again, it is in no way to diminish those responsibilities the deeper you go into a supply chain. So like Lana said, each company has their human rights responsibilities, and the end use is the same for these products. Just because a company is only making one component of a weapon, it doesn't diminish the risk or their culpability.
Cor, anything to add? Yes.
No, I have really nothing to add to that.
Okay. Back to, I think this would be a question for Gillian. So from Stefano Trevisan from Lighthouse Reports, Stefano is a lawyer. To what extent shareholders of an arms company are entitled to access to corporate information related to export deals conducted by the company, whether it is customers, items, human rights due diligence assessments? I suppose that's a question that is very relevant for your research. Gillian.
Yeah, absolutely. I think, again, human rights due diligence is financially material information. A lot of the information around arms sales, specifically since we're looking at US defense contractors, that is public, since most of these do need to go through the federal government. But again, how the company is managing, identifying these risks, that is important information for investors to know. I think where we want to see more disclosure is not just looking at general policies, but how is the company implementing its human rights commitments? How are they ensuring that it's effective? And we're looking at the end use of its products as an example of if it's effective or not. So those examples of pieces of weapons found at the sites of alleged war crimes and other human rights violations, that's evidence that any sort of human rights policy, due diligence process at these companies is not effective, that there are clear and significant gaps here. And that kind of disclosure of how the company is addressing that and working to remediate it is something that investors need to know when they're looking at the broad scope of material risk that a company may be facing. And also pointing to a lot of the new guidance and legislation emerging, treaty on the prohibition of nuclear weapons going into effect. Even if the US is not a signatory, or the state in which a company is headquarters is not a signatory, that doesn't mean that there isn't litigation or regulatory risk. So I guess to sum it up, all of this information is extremely financially material and important for investors to know.
Thank you, Gillian. And I think that's also very relevant questions for banks and also for arms manufacturers. I don't know if Cor, you want to add something, or Lana?
Yes, I'd like to say a few words on this question as well, because sometimes the excuse or the reason financial institutions provide for how should we know, like what kind of knowledge could we have? We can't go and check for every company what type of exporting they are. And I think, like Gillian said, a lot of this is financially material information that they need to know. And even if it wasn't, they should know because of their human rights due diligence. And a lot of it is actually publicly available. I'd like to say that if we can write a report like the report that we've published in July, an investor should definitely be possible to gather the information that's published in that report. We don't have powers that investors do not have. And I'd like to point to a database that has recently been launched. I'll put that in the chat. It's called exitarms.org. It's published by Urgewald and Facing Finance, two German organizations. They've done work on companies involved in getting tar sands and coal out of the earth, obviously because of climate concerns. They've now launched a database that basically lists which companies have engaged in which arms sales to which countries, and any investor can make its own can do its own due diligence helped by that database. I'll put that in the chat, the link.
Super, thanks, Cor. Lana, please.
Just quickly, and to add to what Gillian and Cor just mentioned in terms of unifying the terms between the knowledge, the actual knowledge, and the constructive knowledge, between the know and should know, and this, when it is clearly defined and unified across different jurisdiction, in national legal framework and legislative framework, that will stop exploiting this differentiation, this gap, by certain exporter to find lenient jurisdiction, that they will escape a level of accountability.
Thank you, Lana. I have another question then on the question comes from Balk Rishna-Curvey from the Indian Institute for Peace, Disarmament and Environmental Protection. Apologize if I've mispronounced your name. And the question is, how could international stakeholders curb illegal trade of SAL, light weapons, small arms and light weapons, to South Asia, which is one of the most affected region by this trade? Gillian, maybe, or any of the panelists?
I can give some quick reflections. I think in general, impacted stakeholders should be at the center of solutions. So that is just something that will ground the way that we look towards like mandatory human rights due diligence, what that might look like at the ground level. Again, to how investors look at measuring effectiveness of companies' policies or the effectiveness of regulation, it really is like those stakeholders at the ground, what they're experiencing, that will be able to determine whether or not they're effective or not. So I'll pause there, see if Cor or Lana have anything to add.
Well, I'd like to say that on small and light weapons, this is an area where I think publicly available information could be an issue. We don't have, I don't know of a database that actively collects information on companies involved, or even lists the exports of small and light weapons to various countries in the world. In the basis, of course, the same criteria apply as for other weapon systems. And what Gillian has said about this kind of information being financially material would oblige any company, I think, to share this with especially with investors. But for the general public, it's difficult to get information on the transfer of small and light weapons. So that is an issue.
So I hope that answers the question. If not, feel free to ask a follow-up question in the chat. There's another question that has been upvoted twice. I'm just not sure I completely understand what the question is. So John Podgorelek, I would ask you to raise your hand, please, so that the organizers can unmute you and that you can ask your question live and elaborate a bit. So are the organizers in the background seeing any hand raised for the question?
Try again. Your hand raised and then it disappeared.
So John, can you please try again to raise your hand so that we can unmute you? Great. Welcome, John.
Can you hear me?
Yes.
Very good, thank you. Look, I'm currently in dialogue with a weapons manufacturer from Europe. And all of what you're speaking to, each of your panelists are making great broad points. I'm at the stage where I'm looking for some specificity and trying to, rather than making generalizations, I'm looking to really pinpoint the one provision that I can insert into a due diligence process which would affect give the most bang for the buck, if you like, in respect of ensuring accountability from the company, rather than trying to hand pass responsibilities on. What I'm trying to do is introduce a internal provision which will take it straight to the board, for example, when there is a problem that's occurred or recurred in respect of misuse from a particular client. Do you have any suggestions?
Thank you, John. I think you're pointing to one of the difficulties of human rights due diligence. That is, human rights due diligence is not this tick-the-box exercise that can just be presented so easily. It should be the result. It's a comprehensive process. It's a continuous process. It's a continuous obligation. So that's why it might seem to you and others who are trying to present human rights due diligence measures that would be effective. It might seem to you a bit broad, the presentation of the speakers, but nevertheless, I still want to put this. I mean, your question is very, very important. So I put the challenge to the speakers. Is there? Do you have a response for John?
I can speak briefly around at least our engagement with companies. I think I wouldn't single out something as the most important thing, but at least something that is a first step that is needed before like a company can continue on its human rights responsibilities is acknowledging their responsibility under the UNGPs to respect human rights, developing a public commitment and acknowledgement of this that investors and stakeholders can hold the company to. I'm not sure about European defense contractors, but at least the US based ones, we do not see this at all. But I think if you are digging deeper into that commitment again needs to be public and be actionable. Everything should be based in the UNGPs. Stakeholders should be able to hold a company accountable back to its own commitments, which again should be rooted in international human rights.
Thank you. And Corey, I see that in your report you had asked some banks if they would be ready to prohibit any transaction violating specific norms. So do you have an answer for John?
Yes. Well, there isn't a silver bullet, but so what we see is that the one thing that leads to really like a red flag, I think that's what you're looking for, is so far has been an embargo, an arms embargo, because that's a matter of compliance. And I think as Lana, for instance, has pointed out quite clearly as well, that's the issue that we're talking about, that's simply not enough. Because we see that embargoes, understandably, often are the result of political circumstances, which, however right, may be too limited to achieve what we're trying to achieve here, which is basic protection for people in conflict zones. So what we've done in our report is well, it's not a simple task, but we've made a list of countries based on a couple of criteria that would indicate risk, and our recommendation in the report to companies and also to their banks is to start doing the same thing, or in a different way, as long as you end up with a list of countries that if they apply for an arms sale, if they want to purchase weapons from any company, a red flag would go up, so that the arms company in question would say, well, this country is on our list of high-risk countries, so we need to evaluate this quite extensively, because we're running risks when we're selling weapons to this country. So that would be if you're asking for my one recommendation, that's one recommendation, which I realize falls apart into a set of 6 indicators. So as Gillian says, there's not one solution to this issue. It's really an integrated approach that's needed.
Thank you, Cor. Lana, do you also want to take up the challenge of finding the one recommendation that doesn't exist, but what is the most important recommendation that you would make?
I think, as Gillian mentioned, and Cor, there's no one silver bullet to solve this problem. But I will start with what Gillian rightly said. We need to have a commitment and a policy set in the arms manufacturer to uphold their responsibility to respect human rights. Without this meaningful and to make it public, and that would be very difficult to hold them accountable. And as you as well mentioned, Kanal, it's an ongoing process. It's the human rights due diligence. It's an ongoing process. It's not like we set the policy and put the processes, but it needs to be really reviewed throughout the process in order to feel the level of commitment as well to increase the level of accountability. And if you look closely in our guidance, it's really put in terms of if the companies felt that the human rights due diligence and they are responsible to directly link to contribute to adverse human rights, they need to revisit and to provide, to investigate and to revise their policy, as well as to provide remediation to the victims.
Thank you to the 3 of you. I hope, John, that provides useful information. For you, I want to inform the audience that, as you might have noticed, we are running past the time for this event. This is because there's still quite some interesting questions in the chat. So we will continue with those questions, thanking everyone who has been attending so far, with hoping that people can stay a bit longer, but if not, thank you already for staying for this first hour. So let's take a few more minutes to answer those interesting questions in the chat. One question is from Phil Fikes. I hope I pronounced this well. In the context of foreign relations between nations, how do companies that are heavily engaged in the export discussions within state and Congress affect foreign military sales used by the United States as part of the foreign policy? Because these are sales from the defense contractor to the US, who then exports the defense article. So how do the arms exports by other major international players, example France, Israel, China, Russia, may affect US human rights due diligence? That's another very interesting question. Who wants to take it? May I designate Lana to take on this challenge too of transnational human rights due diligence?
I think when we look at mandatory human rights due diligence in national legislation and domestic framework, that's where we can, the starting point in terms of being consistent, in terms of how to, for companies to uphold their arms, their responsibility to respect the human rights. And as I said earlier in my remark, the responsibility to respect for armed companies exists independently of the state's willingness to uphold their human rights obligations. To answer this very interesting questions, it's part of the challenges in terms of putting for and to prohibit arms export to countries with poor human rights record is the interwave between the arms company and the states. And you've seen a lot of lack of transparency in terms of this particular foreign military sales, that we don't know much of information, and the issues of national security comes at the forefront, where that and the foreign policy, where putting and upholding human rights due diligence would become a challenge, or upholding respect for human rights would be of a challenge. So I think it's an ongoing, and this is kind of complementary process of looking at the state responsibility as well as the companies and everybody involved in this chain of arm exports.
Thank you very much, Lana. Cindy, do you want to jump in on this question? Cindy Epps from the background organization from Control Arms, who might want to link this question to the Arms Trade Treaty. Cindy has raised her hand, so you should be able to speak now. Thank you, Cindy. Go ahead.
Oh, thank you, Canal. It's a pleasure to be here with you and with all of you. And just a quick note to say, thanks for joining Control Arms on behalf of Control Arms. Thank you to all the panelists for these interesting and thought-provoking presentations. A note on the Arms Trade Treaty, which was referenced at the top of the presentations. The Arms Trade Treaty, of course, is the global legal instrument that has the ability to regulate arms transfers based on human rights and humanitarian law. Beginning now to the next Conference of States Parties, which is a conference CSP 9, which will take place next August. The president of this CSP 9 this next year will be the Republic of Korea. And the Republic of Korea has indicated that their focus will be on the arms industry and how it relates to the Arms Trade Treaty. And I thought this was a good point to mention at this stage, because there is, we see there is some ability for the arms industry to engage in the ATT and in these kinds of processes and negotiations, at least on the international or the multilateral level, in terms of implementing the arms trade treaty, both from a government perspective, but also from an industry perspective. And really the hope, I think, especially with this focus on industry this year, is to continue to engage with you all here on this call, but also with arms companies to talk about how they can engage more regularly and more positively with the ATT process in order for sort of these differences between government decisions versus industry decisions, and so that everyone can kind of work together to try to make this human rights due diligence process more effective within companies and to make the ATT process more effective among governments. And really, I just wanted to highlight the importance of the arms industry in the ATT process, because as arms companies think about and implement these human rights due diligence processes, they themselves can actually push governments to do better with regard to the ATT and other policies, and to implement those more effectively. That's just the comment that I wanted to make here, and to the extent that the decisions are, again, with the government in some respects, they're with the companies in other respects. I think from a contractual basis, those can be dealt with between the contracts between the arms industry actors and the government they're selling to, but also requiring some cooperation among both the manufacturers and the governments as to where those the weapons that they are being sold will end up. And that is critical both from an ATT perspective as well as from a human rights due diligence perspective. Thanks so much.
Thanks so much, Cindy. I think we should not keep people waiting too much past of the time, but I still wanted to give maybe Cor the chance of elaborating, if you want, Cor, on the question related to the Equator principles as a source of human rights due diligence for the banks. I saw that you've answered briefly in a written form, but if you want to add anything, please feel free to do so.
Thanks, Canel. No, I think, well, to explain, the Equator principles are another standard, I think, which could be very valuable in pointing out the responsibility of banks. The difference with the UN guiding principles and the OECD guidelines is that the Equator principles are based on a sign-up. So banks sign up to the or subscribe to the Equator principles, which makes them more powerful. So a bank that has subscribed to the Equator principles should definitely be confronted by people asking them, well, you've signed up for these principles. What do you make of it when it comes to investments in the arms industry? But we've referred so far to the UNGPs and the OECD guidelines because of their broader application to all banks, also those that have not subscribed to the Equator principles, and also to other investors. Gillian, of course, is working with investors in securities, so shares and bonds, and we at Pax have also done work on investors in like institutional investors, pension funds, insurance companies, which makes the relevance of the Equator principles not standard in my repertoire. But it's thanks for pointing it out, because it is definitely a useful instrument for those banks that have subscribed to the principles.
Thank you, Cor. Lana, Gillian, any final remarks that you would want to share with the audience? No. Okay, then I would thank you very much, the three of you, Lana, Gillian, Cor, for this. I mean, you gave us an overview that is very broad, but at the same time, very technical, very deep expert knowledge on those questions. Thank you also so much to the audience, because the questions were very interesting and led the discussion I learned a lot, and I guess that was useful for many of the people who were attending. So please, as Jeff has just mentioned in the chat, take the time, if you can, to complete the survey upon exiting this event, to help the co-hosters of this event to improve. Although I personally find that this was a great organization, but there is always room for improve. That is also what should remain probably a principle in human rights due diligence as well. So thank you very much. Stay tuned also for the recommendations, the follow-up resources, as well as the small video that will be provided by the organizers in a few days. Have a good day or a good afternoon.
Thank you, everyone.